Welcome to the deep dive. Today, our mission is pretty clear-cut. We're taking a whole stack of documents, legal briefs, court transcripts, even some technical papers to really understand a crucial 1981 Supreme Court case.
That's right. We're diving into Diamond, Commissioner of Patents and Trademarks v. Diehr et al.
This isn't just some dusty old case. It sits right at this really awkward intersection of physical manufacturing and the very beginnings of computer law.
Absolutely. And for you listening, this case is, it's almost like a masterclass. It shows how the patent system stretches and adapts, or tries to, when new technology comes along.
Yeah.
Especially when it bumps up against old legal ideas like, laws of nature.
And we're going deep. We have 11 specific questions we're aiming to unpack about this judgment.
Exactly. Following the thread, seeing how the court tried to draw that line between just an abstract idea, which you can't patent, and a real transformative invention that you can.
Okay, let's lay the groundwork first. Get the basics down. Question 1. The case specifics.
Right. So, the official name, Diamond, Commissioner of Patents and Trademarks v. Diehr et al. The EL means and others, referring to Diehr's co-inventor, Lutton.
And the case number.
That's no. 7911 RL12. Tells you it hit the Supreme Court docket back in 1979.
Which court's decision were they reviewing?
It came from the United States Court of Customs and Patent Appeals, or the CCPA. Back then, that was the main court handling these specialized patent appeals before the Federal Circuit was created.
Got it. And the timeline. When did this all happen?
The arguments happened on October 14th, 1980. And the decision itself, the big one, came down on March 3, 1981.
Now, this wasn't a slam dunk decision, was it? It was close.
Oh, incredibly close. A 5-4 split. Really highlights how tough this issue was. The majority opinion, the one that really shaped things, was written by Justice Rehnquist.
Who joined him?
He had Chief Justice Berger and Justices Stewart, White, and Powell with him. That was the block that said, yes, this process is patentable.
And the other side? The dissent.
That was Justice Stevens writing for the dissenters. And he had Justices Brennan, Marshall, and Lackman joining him. They had some pretty strong reservations, argued the majority got it wrong.
So a really divided court. What about the lawyers arguing the case? Who are the players?
Well, arguing for the government, for Diamond, the patent commissioner basically arguing against patentability was the Deputy Solicitor General, Mr. Wallace, the government's top lawyer for these kinds of things.
Okay.
And arguing for the inventors, Diehr and Lutton, making the case for the patent, was Robert E. Witchersham.
The stakes seem pretty high, even back then.
Huge, absolutely huge. This was really about whether software, or when tied into a physical process, could even be considered for a patent. A massive question for the, the budding software and computer industries.
All right, let's step away from the legal side for a moment and get practical. Question 2. The facts. What was the actual physical problem Diehr and Lutton were trying to solve? What was their invention?
Okay, so picture a factory making things out of synthetic rubber. Tires, maybe seals, things that need to be precise. The core process is curing that rubber.
Meaning?
Taking the raw, kind of gooey, uncured rubber, putting it in a mold press, heating it up under pressure, and basically cooking it until it turns into the strong, finished product you want.
And the science behind that curing, that was already known.
Oh yeah, perfectly understood. The curing process depends on time and temperature. There's a well-known mathematical formula, the Arrhenius equation, that describes exactly how that relationship works, how fast the chemical reaction happens at different temperatures.
So if they had the equation, what was the problem? Why couldn't they just calculate the perfect cure time?
The classic gap between theory and practice. They knew the equation, but the industry couldn't get consistently accurate cures. The big hurdle was that they couldn't reliably measure or control the temperature inside the thick rubber, inside the mold press, while it was curing.
Why was the temperature so unpredictable? Seems like you just set the thermostat.
Well, think about it. You open the press, it cools down. You put in maybe cool raw rubber that cools the mold surface locally. Then it has to heat back up. How fast it heats up depends on lots of things. The exact temperature inside the rubber itself was always a bit of a mystery moment to moment.
So how did factories handle it before Diehr?
The standard practice was basically playing it safe but inefficiently. They'd calculate the cure time based on the shortest time that would guarantee all parts of the rubber would cure, even if some parts got hotter faster.
Meaning some parts got overcooked.
Exactly. You'd get unpredictable overcuring, which can degrade the rubber, make it brittle, or cause other problems. Or, sometimes if things ran cooler than expected, you'd get undercuring, which means weak spots or product failure.
Yeah.
There was no real-time feedback loop.
Okay, that makes sense. So that's the problem they tackled. What was Diehr and Lutton's specific invention? What did they claim they added?
Their claimed process added 3 crucial interconnected steps on top of just loading the rubber and closing the press. First, they put a sensor, usually a thermocouple, right inside the mold to constantly measure the actual temperature of the rubber during the entire cure.
Okay, real-time data, that's new.
That's the key input, yes. Second, they fed those continuous temperature readings into a programmed digital computer. Third, and this is the clever part, the computer wasn't just doing one calculation. It was programmed to repeatedly recalculate the ideal remaining cure time using that Arrhenius equation based on the actual temperatures it was seeing second by second.
So it's constantly adjusting the finish line based on the race conditions.
Perfect analogy. And then the final step. The computer automatically sent a signal to open the press. The very instant that the calculated required cure time equaled the actual time that had passed.
Wow. So it's not the equation itself, not the press, but the system, the continuous measurement, the constant recalculation, and the automatic control based on that calculation.
That's precisely what they claimed. They characterized their contribution as that dynamic feedback loop, the continuous measuring, the constant recalculating based on live data, and the automatic opening. That whole integrated system was new. It meant perfect cures every time, regardless of temperature fluctuations. That was the breakthrough. Okay, so now we understand the tech. Let's get back to the legal fight. Before we get into the specific arguments, let's pin down the central legal question. Question 3. And this is really important. This case wasn't about whether the invention was new or clever.
Right, it was about something more fundamental.
Exactly. It was about whether it was even the type of thing the patent law, specifically Section 101, was meant to protect. Patent law has categories. You can patent a process, a machine, a manufacturer, a composition of matter, but you can't patent things like laws of nature, natural phenomena, or abstract ideas.
Like EMCR or the Arrhenius equation itself.
Precisely. Those are fundamental truths, free for all to use. So the question wasn't about Sections 102, novelty, or 103, non-obviousness yet. The Patent Office examiner basically stopped them at the gate at Section 101.
So the core legal question, Q3, was basically, did Diehr and Lutton's process, which clearly used a mathematical formula, Arrhenius, and a programmed digital computer, qualify as patent-eligible subject matter under Section 101, or was it just an unpatentable abstract idea or law of nature?
That's the heart of it, yeah.
Okay, now let's unpack the arguments. Question 4. What was the patent commissioner's main line of attack? Why did they say, no, this isn't patentable? They had those earlier cases, Benson and Flook, in their corner, right?
They did, and they leaned on them heavily.
Yeah.
Their first main point was simple. This is non-statutory subject matter. They argued the core of the invention, the steps the computer performed calculating the cure time using the formula, was essentially an algorithm. And under the precedent set by Gottschalk v. Benson, algorithms by themselves were considered unpatentable abstract ideas.
So they zeroed in on the calculation part.
Yes, which led to their second big argument, the dissection argument. They basically said, look, you have to break this claim down into its parts. The physical steps, putting rubber in the press, closing it, heating it, those are all old, conventional, nothing new there. The only arguably new part is the computer calculation.
And since that part, the calculation, is unpatentable under Benson.
Then the whole claim fails. They argued you can't make an unpatentable algorithm patentable just by tacking on old, routine physical steps around it. They essentially accused Diehr of trying to patent the computer program itself, disguised as a process.
That sounds like the argument in the Flook case, too.
Exactly. Their third point was the abstract idea problem, drawing a direct line to Parker v. Flook. In Flook, the Supreme Court had rejected a patent for a method of calculating an alarm limit during catalytic conversion, even though it ended with setting the alarm. The court called that final step insignificant post-solution activity.
Just a trivial use of the calculation.
Right. And the commissioner argued Diehr was doing the same thing, taking the unpatentable Arrhenius equation and just limiting its use to the specific environment of a rubber press, with the open the press step being just as insignificant as the alarm in Flook. They argued Diehr was trying to patent the formula indirectly.
Okay, that's a pretty strong case they're making. Seems logical based on Benson and Flook. So, question 5. How did Diehr and Lutton fight back? What were their counter-arguments?
Their main strategy was to resist the dissection. They said, you can't just chop our invention into pieces like that. Their first counter-argument was, we are claiming a process, not a formula. They insisted they weren't trying to patent the Arrhenius equation. Anyone could still use that equation for anything else. They were patenting a specific integrated process for curing rubber.
Focusing on the whole system, not just the calculation.
Exactly. Which ties into their second point, the practical solution. They argued, look at what our invention does. It solves a real, tangible, long-standing problem in the rubber industry. Inaccurate cures. We're not just manipulating numbers, we're making better rubber products reliably. They framed it as an industrial improvement, not a mathematical abstraction.
Shifting the focus from the how, the calculation, to the improved physical result.
Precisely. And that addressed the fear about monopolizing a fundamental truth. Their third point was about limited preemption. They argued they weren't trying to block anyone from using the Arrhenius equation generally. They only wanted to stop others from using that equation in the specific way they laid out, combined with all the other steps. The continuous measuring, the feeding into the computer, the constant recalculation, and the automatic press opening.
So the patent wouldn't lock up the equation itself, just this one very specific practical application of it.
That was their argument. Since the claim was narrowly tailored to this complete industrial process, it didn't improperly preempt the use of the underlying scientific principle.
Okay, so we have the two sides clearly laid out. The commissioner saying, dissect the claim, it's just an algorithm with old steps, and Diehr saying, look at the whole process, it's a practical industrial solution. This is where the Supreme Court has to make the call. Question 6. What was the final decision?
The Supreme Court sided with Diehr. In that 5-4 split, they affirmed the lower court's decision. The holding was clear. Respondents' claims were eligible for patent protection under Section 101.
A huge win for Diehr, and arguably for the future of software and industry.
Absolutely. Now, question 7, the reasoning. This is where it gets really interesting, because the majority, led by Justice Rehnquist, had to navigate around their own recent decisions in Benson and Flook. How did they justify this?
Where did they start?
They went right back to basics. First, the statute itself, Section 101, and the definition of process. They pulled out a really old case, Cochran v. Diehr from 1877.
1877, wow.
Yeah, foundational stuff. Cochran defined a patentable process as an act or series of acts performed on matter to be transformed and reduced to a different state or thing.
And curing rubber definitely fits that bill. Raw rubber to finished product.
Undisputedly. The court said, look, this is fundamentally a process for transforming an article. It involves changing the physical state of the rubber. This is exactly the kind of industrial process the patent laws were designed to protect. That was their anchor point.
Okay, but what about the commissioner's dissection argument, that the new part was just the calculation?
This is the absolute core of the Diehr decision. The court explicitly rejected that dissection approach for Section 101 analysis. They established the claims as a whole rule, Justice Rehnquist wrote very clearly that it's inappropriate to dissect claims into old and new elements and then ignore the old parts when deciding if it's eligible subject matter at all.
So you look at the entire combination.
Yes. The court said a new combination of steps, even if every single step individually was known, like using a computer, using the equation, using a press, could still result in a patent-eligible process as a whole.
That's a major shift from how the commissioner wanted them to look at it.
Huge. And they hammered home another key point: separation of patentability requirements. They stressed that the question of eligibility under Section 101 is completely separate, wholly apart, they said, from whether the invention is novel under Section 102 or non-obvious under Section 103.
Meaning, don't mix up the question, is this the kind of thing we patent, with, is this new enough or clever enough to deserve a patent?
Exactly. The fact that the Arrhenius equation, or the rubber press, was old was irrelevant for the Section 101 gatekeeping question. The focus was solely on whether the claimed invention, viewed as a complete process, fell into one of the statutory categories.
Okay, so how did they square this with Benson and Flook? They couldn't just ignore those precedents.
They distinguished them carefully. They said Benson was different because the claim there was essentially just for the algorithm itself, converting BCD to binary with no specific physical application tied to it. It was abstract. Diehr's claim, they argued, wasn't trying to patent the Arrhenius equation in the abstract.
It was tied to the physical rubber curing process.
Right. And Flook, they said, was different because the calculation there only resulted in a number, an alarm limit. The court in Flook had deemed the post-solution activity of setting an alarm as insignificant. But in Diehr, the calculation wasn't just spitting out a number for someone to look at.
It was actively, continuously controlling the machine.
Precisely. The computer's repeated recalculation using the formula was integral to the physical process itself, directly causing the transformation of the rubber into a perfectly cured state, a result the court noted was previously unobtainable. The formula was being applied within a transformative process. It wasn't just a calculation existing for its own sake.
So the integration into a physical transformation was the key difference.
That was the crux of their distinction. The formula wasn't being monopolized as a mathematical truth. Its application within this specific practical physical process was what was claimed.
Got it. So question 8. What specific laws or prior cases did the court explicitly rely on to build this reasoning?
Well, the main statute was, of course, 35 U.S.C. Section 101, the eligibility statute itself. They referenced the legislative history suggesting Congress intended Section 101 to include anything under the sun that is made by man, signaling a broad interpretation.
And the key cases?
The core precedents supporting their view were 1. Cochran v. Diehr, 1877, as we mentioned, for that foundational definition of process involving transformation. 2. Diamond v. Chakrabarty, 1980. This was a very recent case where they'd allowed a patent on genetically engineered bacteria. It showed the court was willing to apply Section 101 to new technologies and interpret it broadly. 3. Mackay Radio and Telegraph Company v. Radio Court of America, 1939. This provided that key principle. You can't patent the scientific truth itself, but you can patent a novel and useful structure or process created using that scientific truth. They saw Diehr's process as exactly that, using the known Arrhenius equation to create a new and useful manufacturing method.
And they didn't overturn Benson or Flook.
No, they were careful not to. They upheld the basic principle that laws of nature, natural phenomena, and abstract ideas are excluded. But they limited the application of Benson and Flook. They basically said those cases apply when a claim is trying to monopolize the abstract idea or law of nature itself, perhaps with only trivial application. But when the idea is integrated into a larger, transformative process like Diehr's, the overall process can still be eligible under Section 101.
But again, it was 5-4. 4 justices strongly disagreed. Let's turn to question 9, the dissenting opinion. Justice Stevens wrote it. What was his main problem with the majority's logic?
Justice Stevens fundamentally believed the majority fell for clever claim drafting. His core objection was that they misread the claim. He argued Diehr and Lutton didn't really invent a new way to cure rubber or measure temperature. The only truly novel part of their claim, he insisted, was the improved method of calculating the cure time, in other words, a new computer program.
So he wanted to dissect the claim, just like the commissioner argued.
Essentially, yes. He felt the majority's claims as a whole approach ignored where the actual inventive contribution lay. He saw the physical steps loading rubber, opening the press as just window dressing, conventional steps tacked onto an unpatentable algorithm.
And he saw parallels to Flook.
Absolutely. He found the invention strikingly reminiscent of Parker v. Flook. He argued the final step, opening the press automatically, was no more meaningful or transformative than the insignificant post-solution activity of setting an alarm limit that the court rejected in Flook.
So he stuck to the idea that you had to find the point of novelty.
He definitely focused on that. He argued that if you follow Flook correctly, you have to treat the algorithm itself as if it were familiar prior art when analyzing eligibility under Section 101. And if you do that, Stevens said, all that's left in Diehr's claim are the old, conventional steps. There's no claim of patentable invention remaining.
It sounds like he had a real policy concern driving this.
He did. Stevens was worried that the majority's decision would basically allow people to patent software simply by adding basic physical steps around it. He felt patent eligibility should require a contribution that wasn't entirely dependent on using a computer for calculation within an otherwise old process. He famously concluded the majority's approach would exalt form over substance, letting clever lawyering bypass the ban on patenting abstract ideas.
A really fundamental disagreement on how to apply Section 101. Okay, moving on to the impact. Question 10. What's the lasting legal significance of Diehr? Why is it still such a landmark case?
Its significance is huge, really. First, it cemented the claims as a whole test as the primary way to analyze Section 101 eligibility for these kinds of process claims involving computers.
Yeah.
No more dissecting, at least not for the initial eligibility question. Second, it was a green light for software integration. Diehr essentially said, yes, you can integrate algorithms and computer programs into industrial processes that transform physical things, and the whole process can still be patentable. This is crucial for automation, manufacturing control, and countless industries adopting computer technology. It provided legal certainty.
It didn't say software itself was patentable in isolation, but software integrated into a physical process could be part of a patentable claim.
Exactly. And third, it helped define the boundary of the abstract idea exclusion. While abstract ideas and laws of nature remain unpatentable, Diehr showed that when an algorithm is applied in a practical way to achieve a specific, tangible, transformative result, it can cross the line into eligibility. The focus shifted towards the practical application and integration.
It really shaped how patents involving software were written and evaluated for decades.
No question. It gave inventors and companies a roadmap for protecting innovations that blended software and physical processes.
All right, final question, number 11. We've covered a lot of ground. The tech, the arguments, the decision, the dissent, the impact. If you had to boil it all down, what's the single most important key takeaway from Diamond v. Diehr?
For me, the absolute key takeaway is the concept of integration for transformation. That's the heart of it.
Integration for transformation. Explain that.
It means that a computer program, even one that's just applying a known mathematical formula like the Arrhenius equation, can be part of a patent-eligible claim if it's fully integrated into a larger industrial process, and if that overall process results in the physical transformation of an article like raw rubber being changed into cured rubber.
So the use of the calculation within a process that does something physical is what makes the difference.
Precisely. The practical physical utility of the transformation elevates the claim beyond being just an abstract idea. The fact that calculations were involved doesn't kill the eligibility if the end result is a tangible change in the state of matter. It showed that, for Section 101, the practical physical application trumps the mere presence of mathematics.
That really did set the stage for patents in fields like robotics, automated manufacturing, medical devices.
Countless areas. It basically taught patent lawyers how to frame these claims. Focus on the overall transformative process that the computer enables, not just on the software algorithm itself.
Which, ironically, brings us right back to Justice Stevens' fear in the dissent that the majority focused too much on the drafting, the form, rather than the substance of the discovery.
It does.
So here's a final thought for you, the listener, to chew on. Considering that dissent and how technology has exploded since 1981, think about AI, complex simulations, purely digital processes. Do you think that line Diehr drew between an abstract algorithm and a patentable integrated process is still clear today? Or has technology just outpaced that distinction, blurring it almost completely?
That's the multi-billion-dollar question courts and the patent office are still wrestling with every single day, especially with pure software, business methods, and now AI. The tension Diehr highlighted is arguably more intense now than it was back then.
Something to think about indeed. Thank you for joining us on this deep dive into Diamond v. Diehr.